when a locality wants to do business with a company, and they want to do a procurement, and they want to check on the background of the company's history, they can look around in the public record to try and figure out what's out there. They can see if the company's been sued, if they've had consumers sue it, if they've sued consumers, if they've had problems with their employees, sexual harassment, racial discrimination, all that stuff. It's all that. They're part of the public record. The problem is a lot of companies are now starting to use forced arbitration to basically take consumers and employees out of court and hide it from the public record. And you can't see it. There's absolutely nowhere to see it. 2014, the federal government promulgated an executive order that basically prohibited any company seeking to procure goods or services from the federal government, prohibit them from using pre-dispute arbitration clauses in either any of their consumer contracts or any of their employment contracts. So for those of you who live in Northern Virginia, you might remember Congressman Beyer. He used to use arbitration clauses in his contracts with his customers when they bought cars from his dealership. When this was brought to his attention, he immediately stopped doing it. There's now an act pending in Congress, been co-sponsored by every Democratic member of the Virginia delegation, prohibiting this practice, and by U.S. Senator Tim Kaine. Congressman Morgan Griffith has even co-sponsored a more narrow piece of legislation prohibiting arbitration clauses in connection with sexual harassment and employment claims. So this is a bipartisan issue. And basically what this bill does is it seeks to sort of parallel that 2014 executive order that the federal government adopted. So basically what the bill does, first of all, it only applies to it basically requires a locality to have the option. It doesn't require a locality to do anything. It gives all of our localities in the state the option to request information about arbitrated claims involving either consumers or employees. It excludes senior executives, and it excludes any employees that are covered by a collective bargaining agreement, because presumably they have a labor union that can step in and argue for them. So this is about employees that don't have a labor union, and it's not about senior executives. It also only applies to procurement over $10,000. And basically what the bill does is it requires, if a locality chooses to do so in connection with the procurement, the locality can require a company submitting a bid to show their pre-dispute arbitration clause, their boilerplate, the number of times that they have compelled arbitration in the last 5 years involving either employment claims or consumer disputes, the number of employees or consumers that have opted out of arbitration, if that's an option, and the number of times that a claimant prevailed. That is, the number of times that somebody who's seeking to do business with the government, the number of times that a consumer's prevailed against them, or the number of times an employee has prevailed against them because of, for example, sexual harassment, racial discrimination, wage theft, things like that. And it basically says that this claim history can be considered in the procurement process in determining whether or not the government wants to do business with this business. It requires them to update their submissions every 6 months. It says a locality can terminate a contract based on the submission they get if they get an update they don't like, and it's a local option bill. So basically, again, this bill is about transparency. It's about making sure our local governments have complete information before they decide to do business with a company. It keeps companies that want to get public taxpayer dollars from being able to hide bad business practices or sexual harassment, wage theft, racial discrimination claims. That's basically what it does, Mr. Chairman. And we passed a similar bill, which was much broader last year, out of this body. These problems that I fixed with it were basically related to the issues that were raised on the other side. So I'm hoping that the bill will pass this year. I know there's a lot of people that want to speak to it online.
Mr. Chairman? Yeah, Mr. Chairman?
Yes.
Just to be clear, this is entirely permissive. The local government can choose whether or not they want to do this with their own contracts.
It's 100% local option.
Okay, and to follow up, are there arbitration requirements if there were some kind of secrecy involved in employment in the actual arbitration, the result of the arbitration? They just have to report that it happened, or do they have to get into the results of racial discrimination and otherwise?
I think they have to report that an arbitration occurred and that the claimant was successful.
Thank you.
All right. Are there any other questions of the patron?
Mr. Chairman.
Yes, Senator Hashmi.
Thank you, Mr. Chairman. And Senator, I was just hoping you could clarify the issue of declaring the contractor ineligible within the locality for up to 5 years. Is it specific just to the locality in which there was a violation? And what was the reasoning for this length of time, 5 years, for making them ineligible?
I think the idea is to create the incentive on behalf of companies to comply with the requirements of the contract. I think at the federal level, in the 2014 executive order that was promulgated, it actually created what they called a blacklist, whereas if companies participated in these practices, they weren't even allowed to submit a bid. So this is even more permissive than what the federal government did, I believe. There's some other people on the line that might be able to fill in on that. But I would also, by the way, just note that Congress exercised its legislative veto right, I guess, over the federal prerogative in 2017. After there was a change in control, they passed a law that basically got rid of what the Obama administration had sought to do in 2014. But so that, I think I've answered your question.
Well, my first question was, is if they are placed on some kind of a blacklist, then is it just specific to that locality in which
Yes.
there was a violation, not
Yes.
no other locality?
Only that locality. It says for further on line 98, it says for further contracts with such locality for up to 5 years. So it only applies to that locality.
5 minutes on this bill. If there are a large number of speakers, let's start with the people who are supporting the bill.
Good afternoon. Thank you, Chairman Barker and committee members. Just to clarify on the and safe workplace, that was an executive order implemented by President Obama. It was rescinded in January 2017. It will likely have a good chance of being restored in the coming months. Thank you again. As Senator Surovell had mentioned, this bill has gone through many iterations. We had the opportunity to come back this year with refined language. We worked with the Procurement Officers Association. We listened to business concerns, and we talked to legislators going forward. This bill has been very much streamlined, as Senator Surovell was mentioning. Last year's bill had 19 detailed questions. This year's bill simply asks the contractor if they use forced arbitration against an employee or consumer. The answer is no, that's the end. If it is yes, there's 4 data questions, as Senator Surovell mentioned. This is very important because, as he mentioned, that the information is hidden. Normally, contractors have the opportunity to and requirement to discuss vulnerabilities, liabilities, pending lawsuits, and in their RFP responses. However, that is hidden for forced arbitration. And just to keep things short, one of the areas where forced arbitration is particularly a problem is protecting where our National Guard members who are on deployment, they are unable to secure their federally protected rights. You may have seen our service members on the Hill and our Fairfax County teacher. So we will hear hopefully later from the Reserve Officers Association, who will testify as to what the impact is of forced arbitration. Our coalition consists of the Virginia Poverty Law Center, the Virginia Employment Lawyers Association, the National Women's Law Center, the National Association of Consumer Advocates, the National Employment Law Project, and today the Reserve Officers Association joined our coalition. And I will turn it over to my colleagues in the length of time. Thank you.
Thank you, Chairman Barker and members of the committee. My name is Hugh Barron. I'm a staff attorney at the National Employment Law Project. We're a nonprofit, nonpartisan research and advocacy organization specializing in a range of employment policy issues. NELP testifies today in support of SB 1384. Forced arbitration requirements deny workers the right to go before a judge and jury when their employer breaks the law. Making matters worse, class action waivers incorporated into these requirements prevent employees from banding together to challenge employer lawbreaking. A recent NELP report showed that in 2019, forced arbitration enabled employers to steal $12.6 billion in wages from over 6 million low-paid workers. Relying on that methodology, we find that forced arbitration enabled employers in Virginia to steal $296 million in wages from low-paid private sector workers in the Commonwealth. In addition to facilitating wage theft, forced arbitration is also used to cover up cases of sexual harassment, racial discrimination, and other employment law violations. SB 1384 gives localities the ability to require bidders to disclose information regarding the use of forced arbitration, but it does not require any locality to seek such information. SB 1384 advances localities' interests in the efficient procurement of needed goods and services because these disclosures allow the locality to determine bidder responsibility. A business's record of compliance with workplace laws, as Senator Surovell noted, and particularly its record of complying with wage payment laws, is an important and appropriate criteria for determining a bidder's responsibility. But forced arbitration obscures evidence of non-compliance because arbitrations are generally conducted in secret and behind closed doors, and there's no public record, as Senator Surovell noted. With the disclosures required by SB 1384, the localities will have a more complete and accurate picture of the bidder's compliance with workplace laws. That will empower localities to make responsible contracting decisions, including by avoiding bidders who may be covering up cases of wage theft, sexual harassment, racial discrimination, and more. Thank you for the opportunity to testify, and I'm happy to answer any questions you may have.
Andrea Johnson.
Good afternoon, Chair and committee members. Andrea Johnson with the National Women's Law Center and support the legislation. This is a really important issue for us because forced arbitration is too often used as a tool to cover up sexual harassment and violence in the workplace and other forms of discrimination and prevent survivors from seeking justice and being made whole for their injury. In arbitration, survivors' stories remain secret. And they are often forbidden by non-disclosure clauses from sharing their experiences. The Virginia legislature has already recognized the importance of not silencing survivors by passing legislation in 2019 to prohibit employers from using NDAs and employment contracts to silence survivors of sexual assault. This bill is also an incredibly important measure to ensure justice. It doesn't prohibit the use of forced arbitration, but we think it takes a really important step towards ending the use of forced arbitration by increasing transparency.
All right, thank you very much for your testimony. You got one more? We got one more, and just quickly give us your name and your position on the bill.
Carla Gilbride, please go ahead.
My name is Carla Gilbride. I'm a senior attorney with Public Justice in Washington, D.C. I speak in support of SB 1384 because while these contractual provisions remain legal in the United States and are treated as consensual agreements, in reality, they are forced upon employees and consumers as matters of adhesion. Many times consumers and workers have no idea that arbitration clauses were included in their onboarding paperwork or in long online terms of use that they had no reasonable opportunity to negotiate or to meaningfully agree to. And by shedding light on the prevalence of these practices, by which businesses are using them, localities within Virginia are empowered to make responsible contracting decisions and to share that information, make that information publicly available that all people in Virginia have more information about these provisions.
All right, thank you very much. Any discussion or motion on the bill?
Can I address some of that?
Chairman?
Can I address some of that, Mr. Chairman?
All right.
Unless somebody else has a
Let
question.
me see if there's any deliberation first.
Mr. Chairman, this is Senator Vogel from the screen
Senator
far
Vogel,
away.
yes. Yeah. Senator Vogel.
I have a question for the patron. While I'm very sympathetic to the underlying issues that caused him to bring this bill, I have a question about the preemption piece, and I'm wondering if he would be willing to speak to his position on federal preemption. I'm just curious him to respond on that.
Right. So the Federal Arbitration Act, to my knowledge, only prohibits us from doing anything that results in an arbitration provision being unenforceable. So in other words, we can't pass a law that makes an existing arbitration clause in an existing contract unenforceable. And this doesn't change anything about the enforceability of an arbitration contract at all. It just simply says if you're going to arbitrate with consumers or your employees, you need to disclose that, and you need to tell us how often you've used it and how often you lost an arbitration. Is basically all it says. It's all information. It doesn't make the arbitration provision unenforceable, which is what my understanding of the Arbitration Act the Federal Arbitration Act is directed to.
All right. Any other discussion or questions from the committee? All right. Senator Surovell, you want to wrap up?
Yeah, I'll just say a couple of things. I mean, I'm sort of scratching my head a little bit because some of the largest members of the Chamber of Commerce have now stopped using these types of arbitration provisions in their contracts. Google no longer does arbitration with consumers, neither does Wells Fargo or Microsoft. It's because these provisions it doesn't look very good when you're using arbitration to hide sexual harassment or racial discrimination. And it doesn't look good when you're trying to hide that your services have all kinds of problems by burying it in arbitration. And so that's why these things are on the out. So first of all, I think that there's definitely been a change in how businesses are dealing with this going forward. And I know there's some companies that continue to like to cling to this, but it's a disfavored practice. Secondly, I just want to make clear that there is an exclusion in this for parties that have situations that involve people with significant economic power. If you're an employee in an organization that is represented by a labor union that is there to fight for you and fight for your employment contract, and there's arbitration in that, that's excluded from this. If you're a senior executive, you're the CEO, CFO, CIO, COO, you know, these people have highly negotiated, carefully constructed contracts. Those agreements are out of this. This mainly has to do with sort of mainline employees, people that don't have that kind of bargaining power, and consumers who basically just get boilerplate contracts put in front of them when they click a button on a website or they use services. Those are what you heard is typically seen as contracts of adhesion because you can't really negotiate them. And that's what this is addressed to. It's important that if our local governments are going to purchase services from these companies, and these companies have histories of either poor service or they have histories of racial or sexual discrimination, that the locality ought to know that before they agree to enter into their contract, and they ought to be able to consider that variable before they make the procurement decision. And that's basically what this does. It levels the playing field between companies that don't use arbitration and companies that do use arbitration when localities are asked to choose between vendors. And so, Mr. Chairman, I think this is much narrower than the bill last year. As you heard, the bill last year, they had 19 questions they have to answer. This year, it's 5. This year, this is limited solely to consumer disputes and employment disputes, not everything and anything the company does. We really scoped it down big time this time, and I would hope the committee would pass the bill.
All right, is there a motion on the bill?
Chairman,
Yes.
this is a question for the patron. In thinking through the mechanics, and first off, I appreciate the goal because I think there are some real practices that need cleaned up. My question is more of the mechanics. Specific to lines 83 through 94, sort of the ABC section of compliance for post-award actions, can the patron give an example of what, I mean, for instance, if I have a subcontract that I find has a previous action, or I did have an arbitration suit come up in the middle, does that qualify for a violation and a potential termination of the contract? What would be terms that would, under this as written, come up as an enforceable action under the contract?
Mr. Chairman, what I would say to the senator is I believe if they fail to report the number of requests for arbitration, the number of occasions they filed a motion to compel arbitration, the number of employees that have exercised their right to opt out, or their number of times the claimant prevailed, if they fail to disclose that, I would think that would be a violation, which would then trigger that provision.
Follow-up question, Mr. Chairman. So under 89 through 91, so every time you have a multiple award contract, for instance, and this now, your previous bill last...
You have a what?
Multiple award, okay. So last year, I'll use construction because last year's bill excluded construction. This year's bill does not, so it includes construction. So using that example, I have made an award allowing this as a preference. I'm playing in the locality. Now the contract is let to the contractor. They're doing multiple award buyouts. So at any point in time, they have to substitute a subcontractor. Every single one of them, they've got to figure out all of the information for everyone. What happens if they find a contractor that because of specialties, they have arbitration agreements for some reason. I'm just putting out theoretically. Would they be non-compliant with the terms of the contract because they can't find a subcontractor without this sort of precondition applied on it? As read, can the patron help resolve that? Because that's a conflict I can't quite work out yet.
I think the answer to your question is that it would only be a problem if that new subcontractor does not disclose to the general the answers to the 5 questions. But I don't think just by the fact they've substituted a new subcontractor in that happens to use arbitration, that would give the locality the right to cancel the contract. It only gives the locality the right to cancel the contract if that new subcontractor said, I'm not answering any of these questions, and they in fact use arbitration. And I would just note also, with regard to last year's bill, the reason we carved out construction was because the construction industry historically uses arbitration for fights at the commercial level between, the contractor and a sub or something, but not, this only deals with arbitration relating to consumers and your own employees. It's much narrower scope, and that's a different issue than using arbitration to resolve a dispute about the performance of your construction contract.
All right, any other
One
questions?
follow-up question.
All right.
Just the provision under 72, line 72, 73, in terms of just Freedom of Information Act in relation to all these things. I mean, obviously, it's sort of intentional to, what I understand you're getting at is to sort of expose companies, on if they use them, and therefore, is this going to have a chilling effect on anybody participating? I just don't know, across the wide variety of services, whether there's a whole sectors that may not participate in bids, when basically you're saying all of them are available through FOIA, they're not excluded for every disclosure put in for a public bid.
Well, I would say two responses to that. Number one is, I think without that sentence, there's an uncertainty as to whether or not that information would be otherwise disclosable under FOIA. I would suspect that the bidder might take the position that how many times they've compelled arbitration or how many times they've lost is proprietary, although I'm not really sure I see that. And so we just put this in here to make it clear that it isn't proprietary and it's not excluded from FOIA, because you can get a ton of stuff under FOIA and procurement, a ton of stuff. So that's, I guess, the first thing I would say to that. And the second thing, I can't remember what your other, whether I had something else I wanted to say in response to your question, but.
I think he's let it go, so.
All right.
All right.
Mr. Chair.
Thank you, Mr. Chairman. Senator Surovell, I think I kind of missed where you were going. I thought you were saying if the local government contracted with Mason Industries to provide this service to people in Fairfax County, that you didn't want to allow arbitration between the Fairfax citizen and Mason Industries. It seems like you're focusing on, you want to look at Mason Industries and make sure we're not hiding bad things in arbitration.
Right.
So, Mr. Chairman, we heard the banks. So small banks that may have banking relationships with localities aren't big enough to do, many of the things many of the services they provide. So they contract out with other companies, credit cards, all types of services. If those companies that they use for something that has nothing to do with the banking relationship they're setting up with the locality uses arbitration, would they have to, you said you narrowed down the things they have to report. Would the small local bank have to report that to the city of Williamsburg that says, yes, I use this card company and they use arbitration for these small things, or is that beyond the scope of the questions you're asking them to provide to the locality?
If it is a subcontract or purchase order related to the performance of the covered contract with the participating locality, then it would be within the reporting requirement. And I would also just point out, I remember now the second thing I was going to say in response to Senator McPike, who also asked about whether companies might not bid, which I think also Mr. Nolan said, or somebody said, is that if nobody bids, I would think they would stop asking the question. Like the locality would take that condition out of their RFP, right? I mean, if they're not getting quality bids or they're not getting what they want, they just won't ask. So if it's that much of a problem and they're not happy with what they're getting, they just won't use the authority we've given them. But there's other occasions where they would need the authority. And so that's why it's local option. It doesn't mandate they do it on everything. It just mandates that they do it when they think it would be appropriate. And I would leave it up to our localities to decide if they want to do that. It's just authority for them. And I would note the bill is supported by the Fairfax County school system, which has a $30 billion budget now, I think. And they would like to at least have the authority to do this. I mean, their budget it's 20% of what we spend at the state level.
All right, any other questions?
Senator Vogel, how do you vote?
Senator Vogel votes no.
Ayes 8, no 7.